This phone doesn't stop ringing from people asking about letters of authority. They really don't understand just the basics. They want to know where they can just go and grab it from the internet or off the county's websites. Hi, I'm Darren Findling from the Probate Pro, and we're going to spend some time discussing what is a letter of authority and how you get a letter of authority. So a letter of authority is a document within the probate process that gives the personal representative, the fiduciary, the person in charge of the administration of the estate, the legal authority upon which to act. In Michigan, there are specific rules about how you obtain those letters of authority. So let's kind of break this down and unpack this process. First, the beginning of the process is by filling out some paperwork to establish and open up the probate estate. That's done either by an application for informal probate or a petition for a formal proceeding to open up the estate. Once the court has appointed an individual or two individuals as personal representatives, they have to qualify. They have to say, I accept the responsibilities. That document is called an acceptance of appointment. Another form, like a pre-approved form, you fill out and you file with the probate court. The court also may impose a bond, which is a surety or a guarantee of the performance of the personal representative. That's to make sure that the personal representative, if they steal or do something wrong, that the monies can be recouped from a surety company. So once those documents are filed with the court, then you are entitled to receive this document called a letter of authority. Again, it's a one-page document with an embossed seal. Sometimes there's a gold seal that the court puts on it, and it identifies that you now have the legal authority upon which to act. On that same document, there may be restrictions. It's important that you carefully look at those restrictions. It may have restrictions like that you can't sell real estate without then first going to the probate court and getting legal authority to act. It could have other restrictions on there about your responsibilities within the estate for purposes of identifying whether you can do things or not. But outside of those restrictions, you have the full authority under Michigan law to act as the fiduciary. That goes with it, or with that goes the requirement of all the duties of loyalty, duties to the estate, to the beneficiaries or intestate heirs or testate heirs of the estate, as well as creditors. You have a responsibility to all. And in fact, in Michigan, you have a responsibility to begin the estate and then also effectively close the administration. Quite often, people begin the process, they gain access to the bank account or they sell the house, and they figure, well, I'm done. Why should I bother closing the estate? Under Michigan law, part of your responsibility is to begin it, and part of it is to conclude it. And failing to conclude it can subject yourself to liability. In fact, there's a sanction, including court costs, that the court can impose upon you for failing to appropriately close the administration. Now, this document, this letter of authority, is usually a one-year document, and then you have to go to the court if the estate exists beyond that 1 year, or there's a need to keep it open beyond the year, to give what's called a notice of continued administration, a notice to all the heirs and to the court that you're going to keep the estate open up for another year. For example, all of the estate assets have not been resolved, meaning you haven't sold maybe a house, or maybe you're involved in litigation and it's going on for a long period of time. Those would be some examples of reasons to keep the estate open. But those letters of authority for personal representative are really the key document. That's the document you're trying to obtain. And it's not just, that's not the finish line. That's actually the beginning of this very involved legal process that we call probate administration. So if I could impart any words of wisdom and advice to anybody out there that's watching this video, use a competent lawyer to get you through this process. Because I see people begin the process all the time and have no idea what they're doing and get themselves into all sorts of problems. So hire a competent probate lawyer to not only obtain the letters of authority for personal representative, but to guide you and advise you throughout the entire probate process. If you've got questions regarding this process or would like to further discuss this matter with me, I'm accessible and willing to have conversations with people, whether it's over the phone, in person, or through our website. Call us at 877-YOUR-FIRM or visit us at theprobatepro.com.